May I please as your lordship?
Hello. The issue involved is regarding rejection of the bid of the petitioner. To examine the said issue, it would be required to look into the concerned clauses of the NIT dated so and so. Such examination would require keeping in mind that the status of the petitioner, which is registered as Udyam. The eligibility criteria has been laid down in clause 3. Under clause serial number 2, there is a requirement that the bidder should be a registered company firm and should have existence for at least 10 years as on the opening of the bid. There are other clauses regarding having an office at Guwahati, not to have any history of blacklisting or corrupt practices, having GST registration, minimum average annual turnover, etc. In serial number 8, there is a requirement of having implemented at least one project in central government so and so, with a value of ₹1 crore or more in software development, implementation, and maintenance in DevOps. As observed above, the registration of the petitioner as Udyam is not disputed, and accordingly, the petitioner would get the benefits available under the statutes and policies meant for micro and small enterprise. Provisions of the policy of 2021, which have been relied upon, namely clause 7 concerning mandatory procurement, clause 9 concerning purchase preference, read with the mandatory nature, as would appear from clause 13, are on the aspect that the entity in question is otherwise held to be technically responsive. In the instant case, admittedly, it is the aspect of technical responsiveness as stipulated by the tender condition, which is the subject matter of challenge. The relief sought for in this petition is to interfere with the provision requiring existence of the bidder for a minimum of 10 years. In this connection, the reliance of the petitioner is upon Office Memorandum of 2012-2022, where certain examples and restrictive conditions have been laid down, and one such condition is regard to the requirement of excessive past experience. We have quoted on our careful examination. This court has noticed that a clause of the contract requires existence of the bidder for 10 years, and the same is not on the aspect of experience. The example as laid down in the OM is apparently not covering the aforesaid aspect. Petitioner in the instant case has been registered admittedly on 17/4/2021 as it appeared from Annexure 8.2 of the writ petition. Therefore, it would not meet the requirement of existence of the past 10 years. Incorporating clauses in the tenders are matters which are exclusively within the domain of the owner, and unless such clauses are expressly arbitrary and unreasonable, or the same has been incorporated to suit a vested interested party, the scope of interference is extremely limited. We have quoted Jagadish Mandal and Michigan Rubber. A clause requiring a bidder to be in existence for 10 years for work of high value may not appear to be unreasonable or arbitrary. Ultimately, the credentials and antecedents of the bidder is of paramount importance in the public interest. Writ petition is dismissed. Interim order is vacated. Well,
Maybe please as your lordship.
Yes.
In concern of other side, your lordship, I would like to mention item 329, your lordship.
Yes.
Here, we needed to file a affidavit.
Why haven't you filed? These are all matters.
Yes, your lordship. We'll obtain instruction. Kindly grant us 3 weeks' time.
No, not 3 weeks. We grant you 2 weeks' time. These are all 16, 17 matter. How are you seeking time? Ms. P. Das, Learned Standing Council, Secondary Education, prays for time to file affidavit in opposition. Full stop. Considering that these matters are pending since long, comma, by the final opportunity, comma, 2 weeks' time is granted to file affidavit. Full stop. List after 2 weeks.
Give you.
Item number 329.
Wait, please, Malaj. Malaj, with regard to item number 13 and 14, Malaj, I'm a counsel for the petitioner, Malaj. I have taken the consent from the Higher Education Department, Malaj. Malaj, today the matter may be adjourned, Malaj.
One is of 17. Why are you adjourning?
Malaj, senior counsel, Mr. Aitholi would like to argue in this matter, Malaj. Today he is
Okay.
not available. So, my sincere apologies.
On a request made on behalf of the petitioner, matter is adjourned. To be listed after a week.
Malaj, let me post it after vacation, Malaj, subject to Malaj's convenience. Any day,
To be listed for hearing immediately after the
Malaj.
Puja vacation, 13, 14.
Much obliged.
May I please, Lord? Lordship, with the consent of the other side, I beg to mention item number 11.
Yes.
Lordship, may this matter may be adjourned for.
From the other side.
Yes, sir.
Yes, on a request, you are making a request on behalf of whom? J. Payang.
Yes, sir.
Lordship,
On-
can this matter be fixed after petition?
Have you filed your affidavit?
Yes.
You have filed your affidavit? Oh. A prayer for adjournment has been made on behalf of the petitioner. Para. List immediately after the puja vacation. Yes. 11 और लोड आई होता है हाँ? One to VC request.
Lordship, I senior Mr. H.K. Das is on length in fourth one. Kindly the matter will pass because of pending.
Okay.
Sometime, Lordship.
Okay. Time being.
So like.
May I please?
Yes.
In fact, this matter was heard by your lordship in the last occasion, but since my lord, some time has passed. Lordship, the
Yes.
petitioner who was my lord appointed as an officer in the bank, he was initially placed under suspension and there was a departmental proceeding. And thereafter, my lord, he was degraded to the rank of clerk. And thereafter, that order has been set aside by this honorable court. Your lordship find at page 25.
Just a minute. Okay.
Paragraph 10, my lord.
What had happened? You were appointed as what?
I was appointed as a my lord field supervisor. My lord, this is the officer grade.
When was it?
My lord, I was appointed on 11/11/1982.
Yes, thereafter?
Thereafter, my lord, he was placed under suspension on 24/6/2000.
24/6,
2000.
the page?
My lord, that order because my lord, there are some
Okay. He was placed under
my lord,
24/6/2000, he was placed under suspension.
suspension.
Okay.
And on 29/8/2023,
2023,
2003,
2003. You said 2023, 2003. Yes.
the petitioner was my lord reinstated in the service.
Hmm.
In the initial grade of clerk, which was wrong, my lord, because he was recruited as an officer, but reinstated as a clerk,
Reinstatement is after a DP.
my lord. Page,
After a DP, after the suspension, DP had started.
yes, my lord.
Tell us that.
Page 19 is the reinstatement order.
No, after the DP.
Yes, my lord.
DP started. (28) 29/8/2003. DP culminated with an order of reinstatement.
My lord, that order I have annexed, my lord.
Page
Page 19.
19.
1 minute. Annexure. In response to our letter number so-and-so dated 5/8/2003, the undersigned received your statement dated 11/8/2003, wherein you have given your plea against the proposed punishment. The undersigned has carefully gone through the contents of your outside representation and also through your previous service record and find the extenuating circumstances, if any, the finally decided to reinstate you in the bank service in the initial stage of clerkship.
Yes.
He was never recruited in the clerical grade, my lord. He was recruited to the post of my lord supervisor. My lord, initially he was a clerk, but by direct recruitment, he was recruited as a field supervisor, which is a, my lord, officer grade.
When were you appointed as clerk?
In the year 1980, subsequently petitioner has applied for the post of field supervisor and on complying with the necessary formalities has given directly recruited as field supervisor on 11/11/1982. Prior to that, my lord, he was appointment letter as a field supervisor. I have annexed as annexure A, page 18.
Okay.
Then, my lord, I have challenged the order and this honorable court on my lord 25/8/2008 passed in WPC number 228/2005
Yes, we challenge this, which the reinstatement order,
of my lord.
WPC.
WPC number 228/2005
Against 29/8.
yes, my lord. And
Okay.
judgment dated my lord 25/8/2008 page 21
25/8/2008 is 21. Yes.
The operative portion of the judgment at page 10, my lord. Page 25, paragraph 10.
Yes, please.
Having found that enquiry report was not furnished to the petitioner causing him prejudice, I find that impugned order dated 5/8/2003 and 29/8/2003 are paid in law, the same are liable to be quashed, which I hereby do. However, I leave it to the wisdom of the domain of the respondent bank to complete the enquiry from the page where they have stopped. If so advised, if thus de novo inquiry is initiated against the petitioner, the same should be completed within a period of 3 months from the date of communication of this order. The petitioner shall obtain a certified copy of the order furnished to the same before the authority concerned to do the needful. Then, my lordship may kindly see, after passing of this judgment, the order dated 26/5/2010 has been passed. A departmental inquiry was held into the search frame against you by then chairman of so-and-so bank by order dated 27/6/2001. On receipt of the inquiry report, the then chairman of the disciplinary authority of the bank proposed to inflict punishment of dismissal upon you and also advised to submit comments on extent the punishment. Accordingly, you have sent your submission to the then chairman and disciplinary referee. After consideration of your submission, you were awarded degradation of clerical grade from officer grade by order dated 29/8/2003. Agreed by the aforesaid order, you filed a writ petition number 228/2005 before Guwahati High Court. The Honorable Court passed the judgment that on.
Okay, we have read this, okay.
My lord.
You are reinstated as Officer JMG,
Yes,
Scale 1.
yes.
Yes. Conditions?
Yes, ma'am. Conditions are, my lord, is 27A1.
Hmm.
Your restatement as officer JNT grade scale 1 will be effective from 1/9/2003, effective date of previous punishment with minimum initial case of rupees 20 plus 20. I am not agree. You will be entitled to get basic pay of rupees 20 plus other allowance as per circular of the bank from the date of the letter. Your next annual increment will fall on 1/9/2010. No arrear salary shall be payable during the period of service as clerk cum cashier, with effect from 1/9/2003 to 25/5/2010. I am agreed for this conditions, my in this statement.
What, in that period of 2003 to 25/5/2010,
My lord.
did you discharge your duties
Yes, as a clerk.
as a
As
clerk?
a clerk.
No
Because,
arrear,
my lord, I have been initially reinstated as a clerk, which was wrong, but subsequently realizing the mistake and pursuant to the order of this honorable court.
so
I
what is
have
the meaning of condition 4?
No arrear salary shall be payable during the period of service as clerk cum cashier with effect from so and so to so and so. Arrear salary means, my lord, differential amount, my lord, clerk and officer get that arrear salary, my lord. Since there is a difference of, my lord, pay scale of clerk and my lord, the post of JMG scale 1. The authority said, my lord, I am not entitled to get the arrear salary of differential amount. Although, my lord, it was not very specific in the condition, but I understood that, my lord, and that is the effect of this of order.
Yes, what are your grounds?
My lord, since, my lord, as per the established principle, no person can be degraded to a post in which, my lord, he did not work, and he was not, my lord, requited. That is the established principle of law, my lord. There are so many judgments, my lord. Since, my lord, I have been requited to the post of, my lord, officer directly, I cannot be degraded by way of penalty to a post lower than the postman. And since, my lord, realizing the said mistake and by interference of the honorable court, that order has been modified I'm entitled to get the benefit of differential, my lord, salary amount for the period in
What-
which,
what
my lord, I
decisions
have
are-
worked as a clerk.
What decisions are you relying upon?
Right.
Certain decisions, I think, are on record.
Yes, my lord. One is, my lord, 1988 4 SCC 170.
Just a minute, please. Then thereafter, you have preferred an appeal or what?
Yes, my lord.
Against this, appeal dismissed?
Yes, yes. Appeal dismissed. I have repeatedly filed representation, and finally, the appeal has also been rejected, and against which, my lord, I have preferred this petition. The final order of appeal is, my lord, page 43 annexure act, dated 23/12/2009.
Yes, which decision?
And that order has been passed by the general manager. Appeal was preferred before the chairman. That is also one of the aspects. My lord, decisions. Some copy was furnished earlier.
Yes,
my lord.
you tell us this citation.
Is it, here, my lord, 1988 4 SCC 170, neither thing.
Yes. Yes,
Yes, my lord.
paragraph.
I have misplaced my copy from here, my lord. May I take back that copy, my lord, for a moment, my lord? I have misplaced my copy from my.
एक मिनट, सुन लो। क्यों सबक कुछ?
Very good, 31 and 32.
31.
Yes.
Not 31. These are facts. Okay. Any more?
My lord. Another aspect is, my lord, since the honorable court decided was the penalty imposed upon the petitioner earlier, my lord, he is entitled for all consequential benefits. That is also one aspect.
No, but the court had given liberty to, it was remanded, matter was in fact remanded.
That was remanded, and on the basis of the direction, he was reinstated as a, my lord, officer grade. And since he is, my lord, once he is, my lord, reinstated to the post in which, my lord, he was worked, then, my lord, the part of earlier penalty that does not affect the, my lord, salary of the petitioner, because he's entitled, because, my lord, the authority pursuant to the direction of this honorable court, my lord, reinstated the petitioner in the official grade. That means, my lord, the order which was passed earlier pursuant to the departmental proceeding, that was gone, my lord. That has gone. And the benefit of, my lord, subsequent order, which was, my lord, passed by the authority, that will accrue, my lord, by the,
But the proposal was to dismiss you.
that was, my lord, earlier.
Earlier, proposal was to
earlier.
dismiss
That
you.
was earlier.
But the disciplinary authority took a lenient view
Right.
and passed an order of reduction in rank, whichever you are contending that it could not have been done, and that
Yes.
was interfered by this court.
Right.
That to a cadre which to a post outside the cadre it cannot be done. Within the cadre, the lowest post, it's
So far,
possible.
my lord, the initial proposal of, my lord, removal or whatever may be, that was considered after, my lord, considering my representation. That will not, my lord, come to the way of this proceeding, because that was done by the authority themselves on receiving the representation preferred by the petitioner. But the order which has been, my lord, passed degrading the petitioner, that was wrong. That cannot be done. And as such, my lord, the benefit of arrear salary for the differential amount of the said period, which in which, my lord, I have done my duty as a clerk. And I have in between, my lord, prepared several representation to modify the order. Finally, my lord, prepared the representation. In the said circumstances, my lord, the arrear salary, condition number 4, cannot be, my lord, sustained, because, my lord, lordship may kindly see condition number 2 also, my lord. One, sorry, my lord, 1. Your statement as officer there, G, grade 1, will be effective from 1/9/2003. That effect has been given from the 1/9/2003. And hence, my lord, this period, the condition number 4 should be read together, my. That,
But you did
that-
not discharge your duties in this officer grade.
there
They have
was-
given you the benefits, the notional benefits, and it has been made effective from 1/9/2003. But from 1/9/2003 to 25/5/2010,
Right.
you had discharged your duties as a clerk cum cashier.
Because of the wrong order passed by the authority, my lord, I was compelled to work as a clerk, my lord, to the said post. It was not for my fault. The fault of the, my lord, authority, I am compelled to work as a clerk.
On the issue of back wages, what have you, what decisions are you relying upon?
Back wages, my lord,
Ultimately, it will boil down to back wages. Back wages as an officer. They have given wages as a clerk cum cashier. You say that you should be entitled to the difference of pay
Right.
and the arrears for the period. That means you are indirectly seeking back wages.
yes. Since, my lord, it is not a case of directly for the back wages, I have not brought any judgment, but there are so many judgment, my lord, for payment of back wages. If, my lord, order has
But
been,
back wages cannot be claimed as a matter of right. Ultimately, the discretion is upon the.
but there are, my lord, judgment, my lord, where, my lord, apex court has said, my lord, if, my lord, circumstances is that, my lord, he is compelled to work, compelled to, my lord, that aspect, my lord, I have not.
No,
Take
there are,
over
there,
it,
there
my
are,
lord,
there, are
that is
con-
why-
there are other contra judgments.
Well-
It's not a rule of thumb that back wages will entail
That's
you
true,
to
my lord, that's true, but.
somewhere even
it's-
25%, somewhere 10%, something like that.
That's true, my lord, but,
Because the principle of no way, no work, no pay will also come in.
my lord,
The counter argument of course will be that I was deprived of my from my entitlement to work by a wrong order. That would be your argument.
This, my lord, aspect, my lord, there are judgment both way, my lord, but it's depend upon the circumstances of this case, my lord. The both side, my lord, there are judgment. But since, my lord, it was not that I was willing to work as an officer, but I was not allowed to work as an officer. I was compelled to work as a clerk because of the penalty imposed, which cannot be, my lord, passed as per law.
Okay, what other decisions? What other decisions are you relying upon?
My lord.
Other than Nadir, what other decisions? Neither. Neither.
There are judgment of
Another.
2007, 7 STC, but its judgment has I not got, my lord.
2000?
2007, 7 STC, 689,
What does it say?
my lord, Karnataka, but the copy of the judgment I have not brought, my lord. May I, my lord, pray for some accommodation for, my lord, after some time, my lord, can I brought this judgment?
They're old matters.
My lord, after half an hour, my lord,
Now you've completed your, in the meantime, when Mr. Ganguly,
my lord.
yes, anything else? That
No,
is your case.
This is my case, but I will provide the judgment after some.
Mr. Ganguly?
May it be. Lord, the order that has been challenged is essentially the order dated 26/5/2010.
20?
26/5/2010. That is the order by which the petitioner was reinstated.
Hmm.
And as the counsel for petitioner has pointed out, that reinstatement was a conditional reinstatement, specifically related to condition number 4. That you will not get the arrears salary for this. Lord, the first submission is that, my lord, the order dated 26/5/2010 sought to be challenged by way of a writ petition in the year 2020, when the petitioner filed from service. So between 2010 and 2020, he has not filed any suit or any other writ petition. The
Writ
first-
filed in 2020.
Yes, this writ petition is of the year 2020. And, my lord, though he submitted representations from time to time, but as your lordships are aware, representations do not extend the period of limitation or do not take away the aspect of latches. Here is a case, my lord, where the petitioner has accepted his conditional reinstatement. My lord, he could have taken it or left it. He cannot.
When did he retire?
Close in the year 2020. 2020.
Before his retirement, he's filed.
Yes, my.
Yes. Before the retirement, he filed. My lord, the first aspect is that, my lord, between 2010 and 2020, apart from submitting these letters, and my lord, he himself has annexed very clearly the copy of the decision dated 4/9/2010. Your lordship have perhaps seen, that is at page 31.
Hmm?
Page 31 of the writ petition. This was the decision on his representation, my lord. Very clearly it is mentioned, my lord, Lordship have it. We would like to inform you that as you were posted as officer in the bank serviced by the bank, after your appeal being reviewed by the highest appellate authority of the bank, there is no further scope for review of your present appeal or release of arrears for the period from 1/9/2003 to 25/5/2010. Look, this rejection order was passed way back in 2010 itself. And that was never challenged by way of any other request. That is the first aspect of that. Look, even though the Limitation Act strictly may not apply to writ petition, but the far as payment of arrears is very much governed by the principles of the Limitation Act. Look, I think in your lordship's record, I have earlier on the earlier occasion submitted the decisions. My lords, one was that Harendra Chandra Nath case, my lord, division bench of our High Court. So it is on the file, my lord, I'm not sure. It was submitted. And also, my lord, Tarsem Singh's decision, in which the Supreme Court made it absolutely clear that, my lord, the beyond 3 years of filing of the writ petition, date of the filing of it.
Just a minute, just a minute. Same thing.
Yes, Tarsem Singh had submitted, my lord. 2008-12 SCR 104. Lordship, sir. So if I may take a lordship to para 5,
Just a minute, 2008.
12 SCR 104.
Para?
Para 5 on. A very short judgment at the back. Remedy. To summarize, normally a belated service-related claim will be rejected on the ground of delay and laches, where remedy is sought by filing a writ petition, or limitation, where remedy is sought by an application to the administrative tribunal. One of the exceptions to the said rule is cases relating to a continuing wrong. Where a service-related claim is based on a continuing wrong, relief can be granted even if there is a long delay in seeking remedy, with reference to the date on which the continuing wrong commenced, if such continuing wrong creates a continuing source of injury. But there is an exception to the exception. If the grievance is in respect of any order or administrative decision, which related to or affected several others also, and if the reopening of the issue would affect the settled rights of third parties, then the claim will not be entertained. For example, if the issue leads to payment or refixation of pay or pension, relief may be granted in spite of delay, as it does not affect the rights of third party. But if the claim involves issues relating to seniority or promotion affecting others, delay would render the claim stale and doctrine of laches limitation will be applied. Insofar as the consequential relief of recovery of arrears for a past period, the principles of recurring successive wrongs will apply. As a consequence, high courts will restrict the consequential relief relating to arrears normally to a period of 3 years prior to the date of filing of the writ petition. In this case, the delay of 16 years would affect the consequential claim for arrears. The High Court was not justified in directing the payment of arrears relating to 16 years, and that too with interest. It ought to have restricted the relief relating to arrears to only 3 years before the date of the writ petition, or from the date of demand to date of the writ petition, which was lesser. It ought not to have granted interest on arrears in such circumstances. In view of the above, these appeal well. So this is as far as the payment 3 years prior to the date of the writ petition. But Malod, in same view was taken, Malod, in Harendra Chandra Nath's case, Malod, that perhaps may have on record division bench of our High Court. Lordship, if I may read, the para 4. It has been averred in the writ petition that the similarly situated persons were given same benefit with effect from the date of their joining. In other words, even though the writ petitioners were entitled to get the actual financial benefit from the date of their joining, but by virtue of the order dated so and so, the actual financial benefit was only given from the date of the order, and the pay was fixed in the scale of pay of rupees so and so notionally from the date of their joining. It transpires that the petitioners were appointed on a consolidated fixed pay of rupees so and so per month by memorandum dated so and so, and the similarly situated persons who were initially appointed as the undergraduate fixed pay teachers were given benefit of the regular scale of rupees so and so by the order dated so and so from the date of their joining in the post of undergraduate teachers. And a single judge, while passing the impugned judgment in order dated so and so, observed for obvious reason that the state respondents in the instant case nowhere in their counter affidavit claim that the petitioners and the other undergraduate teachers who were given back wages do not belong to the same class. In this view of the matter, the contention of the state respondents projected to Mr. So-and-so does not hold water. In addition, the learned single judge also noted the respondent number 2 in his note dated so-and-so made observation to the effect that the writ petitioners appeared to have been treated dissimilarly and that the record did not readily reveal any reason whatsoever which resulted in such dissimilarity. Finally, the learned single judge observed that the state respondents have acted arbitrarily in denying the back wages to the writ petitioners and that the ends of justice would be met if the writ petitioners are paid 50% of the back wages minus the consolidated fixed pay already received by them. This writ appeal has been filed being aggrieved by that direction of the learned single judge, whereby and whereunder the respondents were asked to pay the petitioners 50% of the back wages minus the consolidated fixed pay already received by them. Mr. So-and-so learned senior counsel appearing for the writ petitioners appellant submits that denial of full back wages is not based on reason, inasmuch as the learned single judge held that the respondents had acted arbitrarily in denying the back wages to the writ petitioners. While such contention was being projected by the learned senior counsel for the writ petitioners, he was oblivious of that the learned single judge had considered the long delay in filing the writ petition while giving the direction of payment of 50% of the back wages. The similarly situated undergraduate teachers got the benefit of regular scale of pay of rupees so-and-so by the order date so-and-so, and the petitioners for the first time approached this High Court in the year 1998 and thereafter in 2000. Indisputably, there was a long delay in filing the writ petition. In this regard, perhaps the petitioners might contend that where the issue relates to payment or fixation of salary or any allowance, the challenge does not become stale by limitation or the doctrine of laches, as the denial of benefit occurs every month when the salary is paid, thereby giving rise to a fresh cause of action based on continuing wrong. As such, the impugned direction of the learned single judge cannot be held good. The Apex Court on consideration of M.R. Gupta versus Union of India and Union of India versus Tarsim Singh re-enunciated the law in regard to the doctrine of laches in state of Madhya Pradesh versus Yogendra Srivastava, as reported in then they quote the paragraph from Tarsim. Finally, the learned single judge has directed payment of 50% of the back wages. The state amount would definitely be much higher than what the petitioners would have got if the direction was made inconsistent to the law as enunciated in Yogendra Srivastava. Since the state has not filed any appeal against the impugned judgment in order, we are not inclined to examine that issue in view of Yogendra Srivastava. However, the petitioners have got no right to recover their arrears beyond 3 years from the date of filing of the original writ petition. That too in a case where the petition was filed within 3 years of the cause of action. And just to clarify the point, when the cause of action would arise, the article that is relevant of the Limitation Act is Article 7. And that I would rely on one judgment of the Supreme Court along with another of High Court today. Both are so this judgment of the Supreme Court, if I may take up, if I may, your lordship take the first AIR 1980 SC 1773. As to when the time starts, your lordship would kindly come to page 10.
Just a minute. This is Maimuna Khatun.
Yes, Maimuna Khatun.
Paragraph?
No, it's not numbered, Malad, that way. It's page 10 on. Page 10, the last step. Family will not have. So far as this code, that part. Last step. Page 10.
Yes.
So far as this court is concerned, the matter stands concluded by a decision of this court in the state of Madhya Pradesh, the state of Maharashtra and others, where a bench of 3 judges considered this specific question and distinguished the earlier decisions of this court in Jaychand Sawhney versus Union of India and Sakaldeep Sahai versus Union of India. While expounding the law regarding as to when the right to sue actually accrues, this court observed as follows. 3 features are to be borne in mind in appreciating the plaintiff's case from the point of view of limitation. First, the plaintiff became entitled to salary for the period September 16, 1943 up to the date of reinstatement on December 12, 1953. Only when pursuant to the decree dated 30th of August 1953, there was actual reinstatement of the plaintiff. On
These
December,
are all on the matters of plain suit.
yes,
We are not writ petition.
but the principles would still apply because the
Only the
aspect of,
principles, the essence would apply. You
Yes.
cannot go.
that is there, Malab, because nowadays
There is no
Malab,
strict application.
suits are generally Malab, nowadays not filed, they all go in writ only, especially as far as the nationalized banks are concerned. Just to Malab, press home the idea of when the cause of action arose. If I may take your lordship to the next page, Malab, page 12.
Yes.
Malab, the third paragraph. It seems to us.
Hmm.
It seems to us that if we take the view that the right to sue for the arrears of salary accrues from the date when the salary would have been payable, but for the order of dismissal and not from the date when the order of dismissal is set aside by the civil court, it will cause gross and substantial injustice to the employee concerned who, having been found by a court of law to have been wrongly dismissed and who in the eye of law would have been deemed to be in service, would still be deprived for no fault of his of the arrears of his salary beyond 3 years of the suit, which in spite of his best efforts he could not have claimed until the order of dismissal was declared to be void. Such a course would in fact place the government employees in a strange predicament and give an undeserving benefit to the employer, who by wrongfully dismissing the employees would be left only with the responsibility of paying them for a period of 3 years prior to the suit and swallow the entire arrears beyond this period without any legal or moral justification. This aspect does not appear to have been noticed by the courts, which have taken the view that the starting point of limitation would be 3 years from the date of the suit and was for the first time noticed by this court in state of Madhya Pradesh versus French, which seems to us to have righted a wrong which was long overdue. For these reasons, therefore, we are clearly of the opinion that in cases where the employee is dismissed or removed from service and is reinstated either by the appointing authority or by virtue of the order of dismissal or removal being set aside by a civil court, the starting point of limitation would be not the date of the order of dismissal or removal, but the date when the right actually accrues. That is to say, the date of the reinstatement by the appointing authority where no suit is filed, or the date of the decree where a suit is filed and decreed. In this view of the matter, the High Court was in error in modifying the decree of the trial court and the lower appellate court and limiting the claim of the appellant to a period of only 3 years prior to the suit. In view of the findings given by the courts on facts which have not been reversed by the High Court, it is manifest that the appellants are entitled to the entire decretal amount claimed by them and for which a decree was granted by the trial court and the lower appellate will therefore allow this appeal set aside the judgment of the High Court. So the right to sue arises in this case, Manoj, from the date of the 26/5.
But this observation aren't these observation against you?
No, Malod, it is not. Because here, what happened was that, Malod, the
It
law
cannot
was
be
wrongly,
restricted to 3 years.
yes, 3 years from the prior to that statement. Now, here in this case, Malod, in our case, the decision is taken in 2010. Malod,
Kindly read the last paragraph again.
Malod, from
For these
for these
reasons.
reasons. For these reasons, therefore, we are clearly of the opinion that in cases where an employee is dismissed or removed from service and is reinstated either by the appointing authority or by virtue of the order of dismissal or removal being set aside by a civil court, the starting point of limitation would be not the date of the order of dismissal or removal, but the date when the right actually accrues. That is to say, the date of the reinstatement by the appointing authority where no suit is filed, or the date of the decree where a suit is filed and decreed. In this view of the matter, the High Court was in error in modifying the decree of the trial court and the lower appellate. What has happened here, in that case, what happened?
But the High Court's view has been held to be erroneous.
Yes,
High Court limited to 3 years.
Yes, because High Court calculated it from the date of the dismissal. It is not the correct law. The date of the reinstatement would give him the cause of action. In this case, my lord, the date of reinstatement is 26/5/2010. Therefore, had he even come in 2013 with the writ petition that look here, my arrears are to be paid. Assuming that the decision of 2010 is wrong, then he would have been entitled. He has come, challenged the decision of 2010 in the year 2020. Whereas the arrears are due from 2003 to 2010. So, my humble submission,
Not 2003 to 2010.
yes, 2003.
Oh.
That is specifically mentioned in that. 19/2003 up to 25/5/2010. 1st September
Yes,
2000
yes, 19/2003 to,
Yes.
yes,
25/5/2010.
10, yes.
And the cause of action to him arose on 26/5/2010 when he was reinstated, albeit with conditions. So he should have come, even if going by not by the strict principles, within a reasonable period thereafter. If he had to file a suit, he would have to file within 2013, my lord. Now, because he has filed a writ petition, can he be permitted to come in 2020 and claim the arrears, my lord, for the more than 10 years? That is specifically what is pointed out in, my lord, even in Tarsem Singh and also in the division bench judgment. So the starting point is 26/5/2010. He cannot say my representation was dismissed or rejected in 2014, 19, whatever. Because, my lord, as a bank, we ought to have, and rightly so, that if he has given a letter, we have replied to it. That yes, we have rejected, because that rejection also was done in 2010 only. So ideally, he should have come in 2013. Then
So
he
what
would have-
about the 3 years at least?
Yes, 3 years prior to the date of the filing.
Now,
But,
if it was a continuous wrong,
but it cannot be termed as a continuous wrong, my lord, because the
arrears of pay,
yeah, arrears of pay, rightly so, my lord. But even to claim that, my lord, the Supreme Court says 3 years prior to the date of the filing of the writ petition. Now, had he come in 2013, by 2013, fair enough, my lord, you should have got that. Because 2010 to 2013, he has come, my lord, in the year 2020, when the aspect of laches needs to be considered. He conditionally accepted the service, worked the entire term. He has retired in the meanwhile. Can he be now, my lord? Well, this is a case of approbate and reprobate. He cannot blow hot and blow cold. He cannot say, I will choose this part of the order to follow, and I will not choose this part of the order. I will not abide by that other part of the order. That he cannot be permitted to do. And, my lord, I had earlier in the on earlier question, I had also given the learned coordinate bench's decision, my lord, in which the aspect of the Justice Pathak's one decision, my lord, it is not reported. Bhadrakanta sir. Tarsem Singh and Harendranath were, my lord, considered. The lordship perhaps.
Bhadrakanta, yes.
Yes. But if I may just take your lordship to a very short judgment on the first page, the bottom paragraph. Moreover, the claim of the petitioner for his arrear salary was for the period from 1/8/1998 to so and so up to 2003, whereas he has filed this petition only on 3/1/2017, claiming his arrear salary. It is settled law that in a writ petition, no such direction can be issued for any such arrear salary beyond the period of 3 years prior to the filing of the claim. Division bench of this court in the case of Harendranath so and so have held that the writ petitioners have got no right to recover the arrears beyond 3 years from the date of filing of the original writ petition. The Honorable Supreme Court in the case of Union of India versus Tarsem Singh held that the High Court will restrict the consequential relief relating
No,
to
you might be
arrears.
right in containing. It is not a continuing cause of action.
No, it is not.
Because whatever has been fructified, that happened on the order of
26/5.
reinstatement in the year 2010.
Yeah. And
There
continuing had
will be
been-
no change or even addition or subtraction or the amount has, it's not a variable amount.
No.
2010, if he was sanguine, he could have known 2010, from
Yes.
2003 to 2010, this is the arrears which I am entitled to.
Yeah.
And should have been claimed within 2-3
Because
years.
notionally he has got the other benefit. He has got all other benefits except that differential in the salary.
The arrears is not beyond 2010. Arrears is from 3 to 2010.
3 to 2010. So that amounts to
Yes, yes.
crystallized, my lord, on as on that date.
Yes, yes.
My lord, Bhadrakant also says that, my lord, so that is there. And my lord, one last judgment, my lord, of the division bench.
Just a minute, please.
But if I may read this.
Just a minute, 3-5. Yes, what was the other one?
Yes, this is my lord, 2017, 1 Guwahati Law Journal, 606, the division bench judgment. I mean, it's a short judgment.
Shakuntala.
Shakuntala. May I take a lordship to para 2? Permit.
Just a minute. 2017. Shakuntala. One change. 606. Para?
Plus para 2 onwards. This is a short judgment, no?
Para 2.
Para 2 onwards.
2.
Not very long. Yeah. The appellant was appointed as a constable DD on 20/02/1995 in the Central Reserve Police Force organization. But after she completed her year-long training on 20/03/1996, her service was abruptly terminated by the order dated 11/10/1996, as she was declared to be medically unfit by the Chief Medical Officer, New Delhi. Questioning the outcome of the purported medical examination and claiming herself to be fully fit, the constable filed the civil rule to challenge the termination order. The court ordered for a fresh medical examination, but found the second report is based on the earlier report without the necessary medical investigation of the lady constable. Thus, the termination order was quashed by the court on 7/12/1999, and the authorities were directed to take back the petitioner in service. The reinstatement order was challenged by the Union of India, but the writ appeal was disposed of on with direction to convene a fresh medical board with cardiology specialists, and the authorities were allowed to act on the report of the medical board. The appellant was then examined by the medical board, and a positive report was furnished in her favor on 27/3/2001. Thus, the commandant of the CRPF battalion ordered for reinstatement of the appellant on 7/7/2001. But back wages were withheld on the principle of no work and no pay. Nevertheless, the break in service during 11/10/1996 to 2/8/2001 was counted for the limited purpose of Rule 28 of the CCS pension rules through the office order dated 14/8/2001. Agreed by the denial of back wages, the CRPF constable reapproached the court through the WPC number 72. However, the learned judge noted that when the civil rule was allowed earlier with direction for reinstatement, the court did not pass any order for payment of arrear wages. Yet the petitioner failed to file any appeal to seek back wages. The court also noted that service was not received during 11/10/96 to 2/8/2001. Thus, it was observed that it will be incongruous and will not be the spirit of the earlier order passed by the court that back wages be granted. Thus, the writ petition was dismissed on 29/1/2013, and this order is challenged in writ appeal. That counsel Ms. So contains that the appellant was unjustly removed from service as is apparent from the earlier court proceeding, and accordingly it is argued that payment of back wages along with reinstatement would have been the appropriate relief for the CRPF constable. Appellant relies on Dipali Gundu Survase versus Kranti Junior Adhyapak Mahavidyalaya.
This might be too much relevant. Here, there's another leg of argument that there was want of challenge in the earlier round of litigation.
So,
May not be relevant.
perhaps not, because that even that specific thing was not there. And Malad, as far as the judgment relied on by the petitioner is concerned, neither seeing your lordship, I do not have the copy. The last paragraph, Malad, I have noticed, Malad, that it is clearly mentioned in the case of Nader Singh that no back wages were paid, even in Nader Singh. Though the Supreme Court set aside, Malad, the other finding and Malad, ordered for reinstatement, there was no direction, Malad, in Nader Singh to pay the back wages. But, I don't have the exact paragraph, Lord, should we find it in the concluding part, my lord, the point now. About different, the point now, if I may read.
Yes.
The point now is as to what orders are to be made in these appeals. Appellants in the two appeals have been reduced to posts lower than these to which they were initially directly recruited. As these penalties cannot be sustained in the view we take of the rule, in the normal course, the penalties imposed would require to be set aside and the disciplinary authority directed to reconsider which other penalty which it would now choose to propose. But we are of the opinion that it would be somewhat unfair that at this distance of time the matters are reopened. We think, having regard to all the circumstances, the case, the orders that commend themselves appropriate in the two cases are in.
Yes, there is a specific
Yes,
in one, he will not be entitled, shall not be entitled to any difference of salary.
Lordship, for and during the period of reduction. In view of this, we think that the proceedings again should come to it. So even Nader Singh, my lord, though the finding was, my lord, in favor of reinstatement, but
No, Nader Singh is on a different principle that the reduction could not have been outside the cadre.
Yeah.
That's the
yes,
settled
on
point. But
merits, my lord, we are not here, my lord, because even the learned single judge, my lord, in the previous round, Lordship would see that it was not on merit, it was on the core issue of whether because the inquiry report was not, my lord, furnished to him. So merits were not addressed. That is
Mr. Sharma,
Basically, my learned friend argued on the limitation method. If your lordship may kindly see the impugn order. Which was, my lord, dated 26/5/2010, page 27. And immediately 2 days thereafter, impugn order is, my lord, page 27, 26/5/2010.
Mm.
And immediately 2 days thereafter, my lord, representation has been prepared on 28/6/2010, which was forwarded by the officials to the chairman on 28/6/2010, page 28. And representation is at page 30.
30.
First representation, page 30, which was forwarded by page 28. Page 30 is the representation. The prayer portion is under the facts and circumstances narrated above. I, the undersigned, Muntum, humbly and earnestly would like to request your honor to release the arrears salary treating my service as officer with effect from 1/9/2003 to
Yes.
25/5/2010. Then, my lord, another representation which was forwarded on 4/9/2010 by the general manager general manager refused to, my lord, grant the benefits by the order dated 4/9/2010, page 31.
It was not forwarded. The
It is
second
the order, my lord. It is the
Order.
order by the general manager.
Mm.
That cannot be considered and cannot be reviewed. Then, my lord, appeal has been preferred before the chairman.
No, kindly read the contents of this page 31.
Page 31. my lord. I would
Mr.
like to,
Ganguly, contents of page 31.
we
Please
would
note the
like,
contents. No, Mr. Sharma, you please read. Please note the contents.
Good.
You would like to?
we would like to inform you that as you were posted as officer in the bank service by bank after your appeal being reviewed by the higher appellate authority of the bank, there is no further scope for review of your present appeal or release of arrear for the period with effect from 1/9/2003 to 25/5/2010.
That means your first representation was considered. There was an appeal rejected.
My lord. That
This
has
is-
been rejected. Thereafter, my lord, appeal has been preferred before the SAT.
No, it's
It-
not an appeal. It was reviewed by the highest appellate authority. It is
This is-
another representation.
My lord, the first representation has been, my lord, considered and rejected,
Rejected.
considered and rejected. Thereafter, my lord, this
Second
second
representation.
representation before
Where is
the
the
judge.
scope?
My lord, this was, my lord, the lordship may kindly state. It was passed by, the order is passed by the general manager.
General manager is only communicated. CD content. That
They-
is why we're surprised to see the contents.
My lord.
After
Reviewed by
your,
the, hi-
after your appeal being reviewed by the highest appellate authority of the bank.
but no order as such has been communicated. It is, my lord, passed by the general manager. My lord, this general manager said, my lord, reviewed by the highest appellate authority, that has
Yes.
been said. But if your lordship look into the record, there is no order as such. That is passed by the general manager is checked. And subsequent order, which is under challenge here in my lord,
Yes.
the language is
Page.
more or less similar, 43, my lord. Impugn here.
See, this is in connection with a letter of yours of 2019,
My lord.
21/11/2019.
Right.
Or will it give rise to a fresh cause of action?
My lord.
Will it give rise to a fresh cause of action?
No, my lord, since my lord, it has been rejected, then my lord, appeal was preferred. That was my lord forwarded. My lord, lordship may kindly see 18/5/2011 representation, page 32. That was forwarded by to the chairman. In the bottom, my lord, lordship may kindly see page 32. Forwarded to the chairman, AGB Bank, Shoenshu, Guwahati, Shoenshu, for information and necessary action by the general manager.
Thereafter, what did you do?
Then, my lord, lordship may kindly see since nothing was, my lord, communicated to me, then, my lord, I preferred my reminders of that, my lord, is 33 onwards, 33, my lord, 18/5/2011,
No, that is the same letter.
same letter, my lord.
33.
Then, my lord, lordship may kindly see 14/10/2014, reminder,
Page.
page 35, praying for release of arrear salary. Fourteen 2014.
Yes.
Then again on 3/10/2019, page 37, Annex K.
After 2014, next is at 2019.
19, my lord. Because in the meantime, the petitioner has been transferred from here and there. So many transfer order was acted upon during this period. Then, my lord, lordship may kindly see 3/10/2019. Thereafter, my lord, 21/11/2019, page 40,
Page.
page 40, my lord, Annex L. in which, my lord, all the earlier representation has been referred.
Yes.
An impugn order reflects the 21/11/2019, my lord, this last representation.
Hmm.
Again, my lord, instead of my lord chairman, the general manager has passed the order. My lord, there is nothing reflect in the, my lord, impugn order that I order dated change to the appellate authority chairman has passed the order of the section, neither in this order nor in the earlier order
Why, read the second sentence, second line?
of the impugn order, my lord.
Yes.
With reference to the chairman and disciplinary authority, the undersigned has been directed to inform you that the competent authority has carefully gone through the judgment and to ensure against the writ petition numbers to ensure before the Guwahati record of inquiry, day-to-day proceeding, evidence, adduced brief, both side to ensure, and found that the order passed by the chairman of the disciplinary authority by letter dated to ensure 26 is just and appropriate. This order also not passed by the 26/5/2000 order by the chairman. This was also by the general manager. There is no reflection, my lord. The chairman, by which order, my lord, the representation of the petitioner has been rejected. There is nothing in the 26/5/2000 order or 23.
No, but see, at page 27, you said it is not passed by the chairman. It is passed by the chairman. Impugned order.
This is passed by the chairman.
Chairman.
My lord, this is passed by the chairman. It is reflected.
Yes.
This order is under challenge, and thereafter, no, my lord, no order has been passed by the lordship may kindly see.
These
No
are
order
only
has been passed by
communications.
the
These are only
chairman.
communications.
My lord.
These are only communications. He says that he has no, it's not that he has
there is no
considered.
reflection, my lord, by like that, like the impugn order, that is, my lord, by which, my lord, the 26/5/2010, this order is under challenge, my lord. Hereafter, my lord, no order has been passed by the chairman. It was only by the my lord, general manager.
But your reliance on the last question would be your reliance of Niyadar Singh. The last paragraph, though the principles is laid down that you cannot be demoted to a post outside the cadre, but the aspect of differential pay has been clarified.
My lord, paragraph 13 and 25 may kindly be.
We have read 13 and 25, but in paragraph 32. Why didn't you come to the court within time?
My lord,
2010 cause of action accrues, if any, that too for claim of money. 2020 you have filed the writ petition.
Hence, my lord, that order has been. There was a direction, my lord, prayer for review of the decision. Prayer for review, my lord. First, my lord, page 30.
Difficult.
Prayer for review. Review.
How
of
do you overcome 32 of Tarsem? Paragraph 32.
That is regarding, my lord, in the writ court, my lord, that will.
No,
Yes,
Tarsem, the
it is-
principles you are relying upon, there is no problem. Tarsem has also said No difference of pay. You cannot be reduced to a post outside the cadre. It can be the lowest post in the cadre. But from a officer's post, you cannot be reduced to a clerical post. That is okay, no problem. But difference of pay,
So far, my lord, the no pay is concerned, my lord, I would like to rely, my lord, 2007 STC, page 689,
2000,
2007 STC, 689,
689.
my
Name,
name is, my lord, Commissioner, Karnataka Housing Board versus T. Mudaya.
paragraph,
Paragraph 34. Thirty-one, 32 is also relevant, but I would like to rely 34, my lord. We are conscious and mindful that even in absence of statutory provisions, normal rule is no work, no pay. In appropriate case, however, a court of law must take into account all the facts in their entirety and pass an appropriate order in consonance with law. The court in a given case may hold that person who willing to work but was illegally and unlawfully not allowed to do so. The court may, in the circumstances, direct the authority to grant him all benefit, considering as if he had worked. It therefore cannot be contended as an absolute proposition of law that no direction of payment of consequential benefit can be granted by the court of law, and if such directions are issued by a court, the authority can ignore them even if they had been finally confirmed by the apex court of the country, as has been done in the present case. The fault contention of the applicant has no substance and must be rejected. There was a direction for payment of consequential benefit. And in fact, my lord, the honorable court was set aside and was the, my lord, order of imposition of penalty, not only on this ground, my lord, the non-furnishing of the inquiry report also, my lord. In the state circumstances, the consequential benefit will automatically flow. That, my lord, there are some or judgment of this honorable court. My lord may provide this judgment. And pursuant to this direction.
please tell us the paragraph.
Right.
The paragraph. Whether those judgments will really help you, because the remand is only on a technical ground.
Right.
It was the court did not express any observation or opinion on the merits of the allegation. It is only on the aspect that you are not given a copy of the inquiry report.
My lord, the case of the petitioner, pleaded case of the petitioner in the earlier round of litigation, my lord. One of the ground was, my lord, non-furnishing of the inquiry report. Another grounds was, my lord, this imposition of penalty, which cannot be imposed because of this.
But
the honorable court, when
kindly come to the order of this court.
my lord, that's true, my lord. That
Yes.
only on the grounds of non-furnishing of the
Yes.
inquiry report that has been set aside.
Paragraph 10,
My lord,
page 25.
my lord. But the pleaded case of the petitioner, apart from, my lord, non-furnishing of the inquiry report, the penalty imposed was, my lord, not a justifiable penalty, my lord. That was also one of the pleaded grounds of the writ petition. Since, my lord, the non-furnishing of the inquiry report has, my lord, vitiated the proceeding, then, my lord, the court, honorable court, my lord, did not come to the other aspect of it. And in fact, my lord, whenever, my lord, non-furnishing of inquiry report, the proceeding has been set aside and quashed, all the
Here it
consequences.
was not quashed. It was not quashed, it was set aside and matter was remanded. It was not quashed. The intention of the court was to have a remand, and it was remanded, reconsidered by the disciplinary authority. Then thereafter the order was passed.
In one of the case, my lord, lordship may kindly state. In the petition, the, my lord, share civil rule number 5307 to 1998. And judgment dated 19 June 2002. In paragraph 6, in the instead case, prejudice is writ large on the face of the record. Consequently, the impugned order of the removal from service dated 17 to 1998 is set aside, and the disciplinary authority may, in its discretion, continuing with the proceeding from the stage of furnishing the inquiry officer's report.
Yes.
All consequential reliefs following the interference made with the impugned order dated 22 shall follow. And in this aspect, there are so many judgments passed by the honorable court. And hence, my lord, the consequential benefit, including arrears, standard reinstatement, everything has been, my lord, given to the petitioners in all those cases. Hence, my lord, since, my lord, if, my lord, even if, my lord, without going to the merit, it is, my lord, in these cases also, my lord, the order was, my lord, set aside with a liberty to proceed with the stage of furnishing of the inquiry report, but consequential benefits was directed to be given. All those cases. May I furnish, my lord? Put the order, my lord. In all these cases, my lord,
No, we
There was a
cannot
liberty.
go to those orders. You come to the order which is holding the field in your case, paragraph 10 at page 25. Those orders are, those directions will be are pertaining to those petitioners. Here, what is the direction? Paragraph 9 and 10
yes, ma'am.
at page 25.
The
Please read.
dismissal order was so-and-so, which was subsequently reviewed on so-and-so period from so-and-so. The disciplinary authority did not take care, furnish the copy of the inquiry report to the delinquent. The settled position of law is that the inquiry report must be furnished to the delinquent in enable him to make the effective representation before the authorities concerned. Against the proposed punishment, there is certain of the decisions of the apex court in this regard, and we may prefer mention one of those cases, so-and-so versus Ramzan Khan, having found that the
Yes,
inquiry
paragraph
report,
10. Please read.
Yes.
Having found, yes.
having found that the inquiry report was not furnished to the petitioner, causing him prejudice, I find that impugned orders dated so-and-so and so-and-so are bad in law, and the same are liable to be quashed, which I hereby do.
However, yes.
However, I leave it to wisdom of the domain of the respondent bank to complete the inquiry from the stage where they have stopped, if so advised. If such de novo inquiry is initiated against the petitioner, the same should be completed within a period of 3 months from the date of communication of this order. The petitioner shall obtain a certified copy of this order and
Yes,
furnish the
that
same.
is the direction.
Same thing, my lord, the order which I have provided.
No. There in those orders, there is a direction for
My lord, here,
consequential benefits.
here, my lord, the word consequential
It's not
benefit
there.
is not
We
there.
cannot read something which is not there.
Consequential benefit, my lord. But since, my lord, the order, this order has been passed, referring the case of Muhammad Ramzan Khan,
Yes.
here, my lord, consequential benefit was provided.
Ramzan Khan has got nothing to do with consequential benefit. Ramzan Khan is on the aspect of non-furnishing inquiry.
My lord. Since, my lord,
Okay.
order has been quashed, the consequent benefit automatic flowed if, my lord, specifically not, my lord, mentioned in the order of the court. That is my humble concern.
Now, if suppose, let us assume after the remand, you are dismissed from service.
Right.
Is there a scope for any consequential benefits? There is no question of any consequential benefit at all because
From the date of, my lord, removal, I will not get anything. But prior to my lord, passing of the order of removal, the earlier period, if, my lord, I have been reinstated, I will be entitled for the benefit. But from the date of removal, I will not get anything.
it cannot be automatic.
If, my lord,
It cannot be automatic. The judgment which you have just referred, Commissioner Karnataka, it said that no work, no pay may be a rule of thumb, but there can be exceptions. It cannot be automatic. See, it was a continuous proceeding. This court in the earlier round on 25/8/2008 had said that yes, inquiry report was not furnished to you. We interfered in the matter remanded back. Then it is followed by the impugned order of 2010 of reinstatement. Okay, we'll consider.
my lord,
Matter.
so far, my lord, paragraph 18 and 19 of the Ramzan Khan, which referred in this, my lord, while passing this order, Lord, we make it clear that whatever there has been in inquiry officer and he has furnished a report to the disciplinary authority at the conclusion of inquiry holding the delinquent guilty of all or any of the charges with proposal for any particular punishment or not, the delinquent is entitled a copy of such report and will also be entitled to make the representation against it. If he so desires, the non-furnishing of the report would amount to violation of the rules of natural justice and make the final order liable to be challenged hereafter. On the basis of the conclusion, appeals are dismissed and the disciplinary action in every case is set aside. There shall be no order of cost. We would clarify that this decision may not preclude the disciplinary authority from revising the proceeding and continuing with it in accordance with law from the stage of supply of the inquiry report in case where dismissal or removal has been punished.
Okay, we'll consider. Okay. Heard. Sri D.K. Sharma, Learned Counsel. For the petitioner. Also heard. Sri A. Ganguly, Learned Standing Counsel. What do you call yourself? AGVN? AGVN. AGVB, Assam Gramin Vikas Bank, appearing for all the respondents.
Yeah.
Appearing for the contesting respondents. Post up. यही दे देते क्या judgment? No? बाद में देते. The hearing is concluded and judgment is reserved. So इसमें दे देंगे. Okay.
Keep.
Yes. এটা হেৰি আছিল নহয় HK দাসৰ Yes.
Yes, my pleasure, Lord. Chief, in your Lordship, petitioner was appointed as the honorary president of the school management committee, Lordship.
Hmm.
By an order dated 19/4/2020, Lordship, at Annex 7, page 16, Lordship.
Lordship, may I submit?
Yes.
Lordship, the contracting council, Mr. ARB could not turn up today, Lordship, due to health issues, Lordship. So, Lordship, may
Okay, we'll have some other day. Okay. It is submitted that Sri AR Bhuya is not well. AR Bhuya, Learned Council for the S1 number 7 is not well. And accordingly, an accommodation has been sought for para. We'll have it on when? Friday?
This week, Lordship.
Oh,
On this week, Lordship.
Friday, this court will have a problem. Friday, Monday, on Monday. 23rd.
22. Hello.
23rd. 2/3/23. 15. One five. Finance, education.
Here, finance is to file an affidavit, Lordship. On the last occasion also, because as per the affidavit filed by the respondent number 4, they are stated in para 7, there is some WT message that as per order dated passed in this writ petition on 34/2024.
Yes, finance. Madam Musaria for finance, no for education. Finance is to file an affidavit. Any idea?
Mr. Borpatari was there in the court.
Please try to call him. Madam, after a while.
May it please your worship.
Yes.
My lord, the actual matter relates over here that petitioner, who is the wife of the deceased husband who was a government servant, is claiming her husband's arrears salary and pensionary benefits from his lifetime and the family pension.
Yes,
of-
other side.
Respondent number 7.
Yeah, for 7, no, the official respondents. Official respondents, education. Matter is of pension arrear benefits.
Lordship.
22 matter. Why haven't you filed affidavit, madam? It's come for hearing, isn't it?
Yes,
Yes.
come for hearing, your Lordship.
Rule was issued, I think, on last occasion. I think in the month of January.
Yes, you are correct. 24/1.
Yes.
Some affidavits have been filed.
Lordship,
7 has filed, 8 has filed.
other respondents, your
Have you got the
Lordship.
instructions or not?
Lordship, we have received an instruction, and the latest instruction that we have received is that the area proposal for sending the area proposal, a request has been made to the IS Gwalpara, your Lordship.
No, there is a dispute between Mr. Abidin and the
Lordship.
private respondent,
Lordship.
Mullah.
No, I don't.
Is there a dispute?
No,
No dispute.
We forwarded the pension.
You are for whom?
I am for respondent number 7, principal, Dalashwari.
My lord,
Okay,
where,
okay.
where I,
No, if there is a instruction, then we can dispose this off. What is the instructions? Have you
Lordship,
got it in a written format?
It's in a written form, your Lordship.
Can you place it before the court?
Lordship, I'll have to get a copy, your Lordship.
Please get a copy.
Lordship.
If instructions are there, there's no point. After a while.
Lordship.
Mr. Borpudari, some matter of your finance we had required.
Yes, madam, item number 15. But I am taking an accommodation from my lord. I have to reconstruct the file, my lord. I have already received the inspection, my lord. It is with regard to my lord non-payment of salary. So way back in the year like 2000.
No, are you contesting or what?
I'm contesting so far as my lord release of arrears salary is concerned, because my lord the finance
If you
department.
are not having serious objection, then these matters we should dispose of. If you are having a serious contest, then matter will be different.
My lord, can it be, my lord, day after tomorrow, my lord, with all respect, my lord, if it can be, my lord,
Okay, Monday,
Monday.
madam.
Monday, Lordship, I'll not it. Can be after Puja, Lord.
Then you can reconstruct the file. Okay,
Well,
That
Um,
would be better.
okay. A joint request has been made for adjourning the matter. Para, Sri Borpujari, the learned standing council finance department has further informed that the file is required to be reconstructed.
Well-
Full stop. Para, list immediately after the puja vacations. Yes.
I'm so obliged.
Item 1 and 2. So I'm extremely sorry for the morning hours, my lord.
One and what is 1 and 2? Nayar is appearing in which matter?
I mean, item number 1 for Cotton University, my lord, respondent number 6.
Okay,
My role is very limited, my lord.
okay. Would like to take up which matter?
Item number WPC, my lord, 2556.
First matter.
First matter, my lord.
Okay.
In a nutshell, issue is that, my lord, we are basically praying for similar benefit which has already been given to other similarly situated persons, my lord.
Yes.
There are 6 petitioners, lordship.
In 2556.
Yes, 2556, my lord. There are 6 petitioners. All are, my lord, lecturers in Cotton College.
Just a minute, just a minute. Let me see the names.
Yes, my lord.
Still serving or what?
Still serving, my lord.
Just a minute.
I hope, my lord.
At least 2. In the first, at least 2. Second,
That's why,
second,
my lord, I said, I hope.
second, let us see the second one.
Second one. No, otherwise connected, my lord. If the first one goes, then it will be difficult for.
I am just having a look at the names.
Yes, my lord.
Nath, then Mohanto.
Yeah, hold it.
Chakraborty. Second, I did not have any issue, but it is connected. Place before any other bench.
I'm
Place
sorry.
before any other bench without me.
I'm sorry. Much obliged.
Obliged, my lord.
May pay for it if possible.
15 matter, this will come.
Deeply obliged.
17, yes.
May I please, Lord? But this matter relates to promotion from tutor assistant professor to assistant professor, Lord. The last occasion instruction was so far from the respondent.
Higher education.
Yes,
Mr. Gogoi.
Lordship, in this case, Lordship, we have sought certain clarification on the Magad University, Lordship. One letter is come from the Magad University, Lordship.
Magad University.
Magad University.
Where is it? Where is Magad University?
Magad University, because the petitioner is obtained the PhD degree from Magad University.
No, where is it? Magad?
In Bihar, Lordship.
Bihar.
Bihar. And Lordship, there is a issue, Lordship. Almost, Lordship, now we have verified, Lordship. More than, Lordship, 700 persons who are still working in the college.
Now, do you have the instructions or not?
Lordship, here, this matter, Lordship, we have to place the Lordship High Power Committee which has constituted for verify the Lordship PhD degree, Lordship.
That exercise is on.
Exercise is going on already, Lordship. 370 was identified, Lordship. So, Lordship, I posted the matter after Lordship 4 weeks.
Your name?
L.
Sanktam.
Sanktam.
Hmm?
L. Sanktam.
Heard Sri L. Sanktam, Learned Counsel for the petitioner. Para. Sri K. Gogoi, Learned Standing Counsel, Higher Education Department has, however, submitted that a detailed exercise, detail में ED मत लिखिए, detailed exercise is going on for verification of the PhD degree obtained by a number of students, including
Number of lecturers.
number of candidates,
Yeah, yeah.
including the petitioner herein. Full stop. He accordingly prays for and is granted 4 weeks time to come up with further instructions.
Lost, sir.
List after 4 weeks. From the Magad boli kaise ki? Magad bola hane mein. Bola PhD degree obtained from the Magad University.
May I please pray for a date?
List on 23 matter. 4 weeks will come. List immediately after the puja vacations. Okay. The other matter at Arcelor 16. Put go delay nahi kagaz khan. Yate print logo par letin. Okay. Where is Madam Musari gone? Print we could have got here itself in the court. Just in brief, Mr. Abedin, what is it? We are not making any notes, just before she comes.
Yes, sir.
What is it?
Well, this person joined in service as a subject teacher in Arabic in one Jalashar school.
Your husband?
Yes. Then, my lord, from 1978, from 1978 to 1989, he was in Jalashar only. So, my lord, that ultimately qualifies the pensionary because more than 11 years over there. My lord, what happened on 5/8/1989? A transfer order was issued. He challenged that transfer order and it was stayed. But before the stay could be implemented, the other side person has joined.
Okay.
So I was in a hanging situation, remained hanging. Then after that, because of that situation, that person has already joined. Ultimately, the matter was heard and the court decided to vacate the interim order. Then I remained as hanging. I did not join there. Ultimately, no. Then what happened? They have sent me to another school, Krishnai. I went there. So in Krishnai, when I went there, they did not allow me to join. 2 reasons. One, I did not have the release order from the Jalashar as well as the last pay certificate. The Jalashar was saying, your stay was there, that was vacated. So you don't belong to me. You belong to the transferred school. You get the release and the last pay from there. So I said I did not join over there. So my last pay was from here. You give it to me in 89, what I received it last. Ultimately, my lord, is a kind of a threatening order from the director to the Jalashar. You give him the last pay, otherwise face the consequential consequence. And at the same time, an order was given to the Krishnai. You allow him to join, rest we will see how the last pay is given or not. But don't keep him hanging anymore. So I was allowed over there. I served. What happened, my lord? During that period, I did not get my salary.
What is how much is the period?
That is one, my lord, actually 23/12/1992, 31/1/93. Then 1/2/93 to 36/96. My lord, these dates are a bit confusion because what happened, to be very honest, my lord, I am a lady who did not know much about this service matters and all this thing about my husband's this legal problem. Incidentally, what happened, my lawyer also, as your lordship is aware that.
He has
Mr.
passed away.
Yes, yes.
When did he pass
92
away?
I retired and 2011 I
Husband
passed away.
retired. Husband retired.
Husband retired and husband passed away 2011. And most probably, my lord, 2013, if your lordship remembers, Mr. Hussain, that old man was with Mr. A.S. Chaudhary. At one stage, he used to come to the court with that stick. So he expired in the year 2013. He was handling the case. After the death, I though came to his chamber, but I did not get anything. Somehow, my lord, this writ petition was constructed from the earlier writ petitions and orders of this honorable court. And now, my lord, my
now
main.
what is the instruction? You are for the Jaleshwar College. Okay. You don't have much of a role, I think. Do you have any role?
Just joined my lord on 1/1/2020.
You don't have much role.
The only thing was that there was a order was.
You
given
joined means you are the principal or what?
I am
principal.
You are not been named by, not named by, made party by name.
No, no,
No.
principal.
principal.
Present incumbent might have joined. You have to check the records.
My lord, no,
Madam Musari, you could have got the print here.
my lord, that is admitted. My joining and all this thing is admitted.
Okay, what are your instructions, madam?
Okay. The instruction is that
Can you pass over a copy to Mr. Abedin?
Lordship,
You have another copy? Don't have.
Lordship, from 1988 to 89, he was posted in Jaleshwar High Secondary School, your lordship.
1978.
88.
1988 to 89.
Hmm.
Then he was transferred, your lordship,
Yes.
to Jaleshwar High School. However, in the meantime, he had filed a writ petition and his transfer order was stayed, your lordship.
Hmm.
In his place, your lordship, one Motiur Rahman was transferred in Jaleshwar. Motiur Rahman, he joined in Jaleshwar post, your lordship. So even though it was stayed, he could not join,
I think you need to place this on affidavit.
lordship.
There will be some dispute. You need to give a proper opportunity. You read towards the last part. There is no record.
No, but initially the second line, the third line is also wrong.
Let them prove.
Yes, my lord. It's not 88. What I'm saying, telling my friend,
78. You have
it's
to-
78.
78, your
It
lordship.
is already admitted by this, the director as well as
Okay.
various.
Heard Sri J. Abedin, learned counsel for the petitioner. Sarah, also heard Ms. D. Musahari, learned standing counsel,
Secondary education.
secondary education department. Put stop. Sri Mullah, learned counsel is present for the respondent number 7. Para. Ms. Musahari has placed before this court copy of a communication dated 19/3/2024 by the director to the department on the present case. Full stop. Let an affidavit be filed based on the said communication to enable the petitioner
Wait.
to not to enable the petitioner to give the petitioner a fair opportunity. Para. Let such affidavit be filed within a period of 3 weeks from today. Okay.
My lord, the communication, my lord got it is
No,
it? Oh, is it second one? One. No, you can keep it. I don't need it.
What is it?
No, I got it the 2nd March to
So It's
2024.
the same, your lordship. It was sent to the, it's the report, your lordship, and that report has been.
If it is 78, my lord, that admittedly 78 to 80.
No, they have seen the no records, but you communicate with the college also.
Lordship,
No records, obviously no records. He was not there. He was hanging.
lordship.
Try
No,
to
no,
recall.
no. Hanging period was after 89, after the first transfer. 78 to 89, I was there. That is
Then
already
why
admitted.
no records?
Is admitted, but over here this date is wrong. Record is after
Lordship.
that. What they're saying.
Okay.
Deeply obliged.
আচ্ছা মোক এটা